Hello, everyone. I'm Dwight Mitchell, the founder and executive director of Family Preservation Foundation. Welcome to our Child Protection Series Pro Se Help Kit video series. I hope you enjoy the content and it allows you to better understand your rights and options as it involves CPS or Child Protection Services. As most of you know, after a 24-month battle, I successfully defeated Dakota County Social Services and had my children returned to me while representing myself pro se. Although filled with anguish, it was an educational experience to say the least, and I will be passing on some of the benefits of my knowledge and lessons learned while cross-referencing Minnesota state statutes, case law, and other topics which are readily available on Google Scholar. I'd like to advise you that I'm not an attorney. I'm not licensed to practice law, nor am I providing you legal services whatsoever. I recommend that you obtain your own attorney whenever possible and review my video series entitled Working with Your Attorney. This is a very important unit in our series and will assist you in not being misguided like I was by my attorney's legal strategy, incompetence, and or greed. Every attorney has their legal strategy, and it's up to you to understand what's being presented to you, and you must, work with your attorney to a successful outcome. So having said that, this video series is for educational purposes only. I will go over the beginning, middle, and the end of the entire CPS process. If this is the first video unit you've looked at, this will be hard work for you and a lot of reading, but nothing in life that is worthwhile is free. The Minnesota templates I provide are examples only and are not to be used as is. They're examples for you to make up your own documents. You have to create your own court filings because you are acting in a pro se capacity, meaning for yourself. I do not have examples of everything, but ask other group members because they may be able to help you. But remember, you are not allowed to stand in court and say that someone helped you or told you what to do or what to say in a certain way. That's just not possible. You're doing this for yourself. And so whatever it is you say or read, it is, you doing it for yourself and you're submitting it for yourself. This is just an educational series on some of the things that you should be doing and what you should not be doing. So the title of this unit is To Know Your Rights and What to Say if CPS Comes Knocking at Your Door. A lot of you ask this question. This is a question that is asked quite often. We have about 6,000 members, and that this seems to be a concern for people who have CPS calling or have had or know of someone or neighbors or friends or relatives or just for educational purposes. What you should know is you have the same rights that you would have if you were being interrogated by the police for a crime. Even though this is a dependency proceeding and civil in nature, the same fundamental rights are at stake as they are in a criminal proceeding. You may essentially lose your family, and that's a liberty interest which is protected. All of the liberty requirements come into place. The warrant requirement for coming into your home, for doing a search and seizure, the 14th Amendment due process requirement, all of these come into play in the context of CPS also. Always be polite, ask for ID, ask exactly what the charges are. Hostility is considered guilt in the eyes of the CPS workers, and it really doesn't get you anywhere, even though you may be embarrassed or flabbergasted. It is what it is. First and foremost, take the allegations seriously. I don't care how absurd it may sound to you or unbelievable what the caseworker is saying to you. She is very serious. That's why she's at your door. They screen in and screen out calls. They have 3 criteria that they use before they even show up to your house. The person making the call, does the person identify themselves? Do they give an address and contact information? how serious the allegations are. Do they sound believable? Can the person on the other end of the phone corroborate their findings or provide evidence if necessary and required? And have you received multiple phone calls? Is this the first time a call of this nature has come in, or has multiple calls come in? So if she's at your door, 9 out of 10 times she already believes you're guilty. She's there just to collect the evidence to move the case forward. Know this: anything you say can and will be used against you in a court of law, and it will be twisted. And when I say twisted, unlike in criminal proceedings, in civil proceedings, they are not required to provide exculpatory evidence. That is evidence to prove your guilt, your innocence. I'm sorry. Exculpatory evidence is evidence to prove that you are innocent, that they have, but they don't want to give to you, and they're not required to give it to you, and they're not required to present it to the court. This is one of the things that I found shocking, to say the least. So it's up to you to present all of your evidence to the court, not to the social worker. The social worker is trying to find you guilty of child abuse. She actually believes you're guilty, and that's why she's at your door in the first place, so she can collect hard evidence. It is your job to put up a defense and to stop the collection of this evidence. If your caseworker starts accusing you directly while she's at your door, just very politely say, I must speak with my attorney before answering any of your questions, and give me your card, and I'll call, and my attorney and I will set up an appointment to come down and see you. Just cut it short. To be blunt, just shut up, and shut up right now when a social worker is at your door. This is most parents' single biggest mistake. And the reason they don't do it is because they feel, well, I'm innocent. I just need to explain it to this woman. And of course, she's rational and she'll see it, or this man, or whoever the caseworker is. And that is not the case. They already believe you're guilty when they're at your door. Please understand that no is a full sentence. Yes and no. That's all you have to say, and I'd like you to leave. It is extremely important for you not to submit to a CPS interrogation before talking to your attorney. Don't answer any questions at all. It is natural that you'll want to defend yourself and tell the CPS person, what's going on, or the allegations, or the next door neighbor said something. She's not there for that. She's not there to hear your side of the story. Tell it to the judge, and that's what it's really for. She's there to collect her evidence to prosecute you. So you need to be quiet, remain silent, contact your attorney, tell her you want to speak to your husband before you answer any further questions. So, as I said, the caseworker is there to find evidence to support what she already believes, and if she's at your door, they already believe you're guilty. Do not assume that the social worker has a court order or even enough evidence to get a court order. Having a court order and a warrant is very, very different. Sometimes they'll come to your house to get the evidence so they can go back to the judge and get the warrant. So by you being silent or saying, I'll come see you with my attorney, that shuts off their, evidence collecting ability, and it helps you build a defense. They cannot come into your house without a warrant and a court order unless there is an emergency taking place. That is the one caveat. If someone calls 911 and says there's a domestic incident or an altercation or something of that nature, then, not CPS, the police have the right to come into your house without a warrant. So if CPS shows up without the police and they don't have a warrant, you do not have to be intimidated. If the police says you have to let me in, say only if you have a warrant. If you don't have a warrant, bye-bye. And just close the door. And that's it. That's all you have to do. It really is just that simple. You don't have to talk to them. Child Protection Services cannot simply take your children away from your home. So, they're working in confines of the law just like you do. They know how to manipulate the law a little bit better than you, but they cannot take your child unless there's exigent circumstances or an emergency. And when they say exigent, you have to ask them, what is the emergency? How is it that my child may die at this moment if they are not left here? And it is best for you to record everything, especially if they are in your house and you need to ask them these questions. And these are very, very important questions, because if they can't state what the emergency, the life-threatening emergency is at that instant in time, then they cannot take your child. And if they do, you have a very good case when you go to court to the emergency protective hearing, because they could not state why they removed your child and what was the emergency at the time of removal. So that's very important. The same policy applies to schools and to hospitals. They cannot take your children away from schools. They cannot take your children away from hospitals unless they tell you specifically what the emergency is at that time and how there is imminent harm or death happening to your child. There is plenty of case law in Minnesota regarding this. The Eighth Circuit has explicitly said that Child Protection Service cannot remove your children unless there is imminent danger of that child being harmed immediately. So the next thing is you need to find the right attorney. And I'm here to tell you it's difficult. I had what technically was one of the top attorneys for child protection in Minnesota. I mean, the first day I came in the court, the judge knew who the attorney was, knew the attorney's father. It was supposed to be this crackerjack win-all attorney. Well, I ended up firing this attorney and representing myself pro se. So finding an attorney who has experience fighting CPS, and note, I said has experience fighting CPS, can give you references. You need to check the attorney's references. Don't just take an attorney's word for it. Say, let me speak to some of your clients that you've successfully represented in CPS cases. And if an attorney doesn't want to do that, well then that's not an attorney you want working for you. The sooner an experienced attorney enters into the picture, the sooner you can put a stop to the abuses of CPS tactics. Public defenders and some attorneys believe their role is to find out what CPS wants and to make sure their clients do it. This often, to me, leads to disaster and child loss for the parents. So if you have an attorney that's telling you cooperate, go along to get along, if you listen to the CPS works, you'll get your child back faster, that is absolutely false, and that is not the law in Minnesota, and it is time for you to find another attorney. If a public defender tells you that you must, plead guilty or admit to services or take the services, that is not true, and that is against the law. CPS is supposed to bring you to court in 60 days and present evidence to the court of your abusiveness. If they cannot do that, then they have to return the child. So in the first 60 days, there should be no cooperation whatsoever outside of visitation. You don't need to sign any forms, any documents. You don't have to do any case plans. So if a lawyer is telling you to do this, you absolutely have the wrong lawyer, and you need to tell him, no, this is what you're going to do, and you need to put it in writing, and they need to sign it. And they say, I don't care if you agree with it or you disagree with it. You're representing me. This is my case. This is my child. You know the law. Unless you can show me something differently in the law, this is what you're going to do. Under no circumstances should you let any government agent or official into your home unless he or she has a court order. Hands down. I don't care if you want to prove to them my house is sparkling clean, they'll find something. And if you do allow someone into your house, make sure that that you record the whole time that they're inside at your house. And it's best to have a witness. Bring your mother-in-law, bring your sister or whatever, but don't meet with CPS by yourself. always ask to see the warrant or court order. If they have it, make sure it's signed and dated, when it's signed by the judge and dated, and it specifically outlines what they're allowed to do or what they aren't allowed to do. A lot of times CPS will take an order and that a judge gives and try and use it as a blanket catch-all order. So, read the warrant carefully. Don't believe the claims. Well, it's an emergency. We have to come in. We have to see your child. We have to make sure everything's okay. If it was an emergency, they'd be kicking down the door. They would not be asking you to come in. If they're asking you to come in, it's because they don't have permission, they don't have a court order, and they want you to voluntarily let them in. If you voluntarily let them in, you have given up all of your rights. Anything they see, anything that's in their line of sight, anything they hear, it can all be used against you in a court of law. So don't let them in your house without an attorney. And there is no exception to this policy. There is no maybe, there is no if, there is no but. Do not let them in your house. Plain and simple, no warrant, no entry. That's it. So if you invite them in, you have waived your Fourth Amendment protection, and there's nothing you can do about it. You can't get it back. Something that people ask me a lot about is, can CPS talk to your children without your permission? They can't come into your house and talk to your children. So if they're at the door and they don't have a warrant and they're asking to speak to your child, just tell them no. Say, no, I respectfully decline or refuse to let you talk to my children. They can talk to your children outside of your home. If they can go to school, that's the law. So they don't need your permission to go into a school or some other public place and speak to your children. What I do advise parents to do is to talk to their children about talking to strangers, especially about things in the family, the household. Give the child a 3x5 card, tell them to put it in their backpack, and if anyone tries to talk to them or question them about anything whatsoever, about mommy, daddy, the household, have them give that person a 3x5 card, and on the 3x5 card it says, I'm not allowed to speak to you, about anything in my household or strangers without my mommy, daddy, or lawyer present. Just that simple. Put your name on it and your telephone number. Give that to your child, and then tell your child anytime someone asks to speak to them about anything concerning the family, that you have to be present, or your attorney or your lawyer or something of that nature. So the next advice I'm going to give you is to record everything. Take notes on everything, write everything down, do everything through email, but you must keep a record of everything. Video record everything if possible. You can tape all conversations with CPS. They hate being taped, but it is perfectly legal to secretly record. If they don't give you permission to record it, you can still record it. As long as you're a part of the conversation, you can record any conversation you're a part of. So get a tape recording app for your smartphone so that you can record all your phone calls. So if CPS calls it in, you turn on your recorder and you can take the call. Preferably keep the calls as short as possible on the phone. You want to do everything in writing. You want the CPS worker to send you the information in writing. When you email back the worker, make sure in Outlook you can do it's called certified copy receipt. So what it is that when a person opens your email or receives your email, you'll get an acknowledgement back. And if a person reads your email, you'll get an acknowledgement back also that the person received the email and that the person read the email. If you don't have Outlook, say you have Gmail or Hotmail or something else, please write at the bottom, please confirm that you received this email. So every email you should have, please advise me that you've received this email. If not, send another email until you get something back in writing. If you don't get something back in writing, then you can acknowledge the court. I sent these 3 emails on these 3 days and I didn't get a reply. And then you send the letter or the emails to the prosecutor, to the court, to the social worker, certified mail return receipt. It costs a couple of dollars. You send it out certified mail, you'll get a receipt back from the post office that says the document was delivered. You take the green receipt that comes back from the post office. You take the letter, you staple it to the letter, and then you put it in your binder. I tell everyone to create a 3-ring binder and keep everything organized and separated. This is a very paper-intensive process, and these papers are very, very important, especially showing that proof that you did something. In case the social worker comes down later on and says, well, you didn't do it. Well, now you have proof that you did it, or that you sent it to them, and that you complied with whatever they asked you to do. Do nothing at all based upon what the social worker verbally told you to do. I can't tell you how many times people have said, I've done what she told me to do, and then later on she changes her story before the court. So it happened to me. It happened to so many of our members. Please make sure you do everything in writing. You know, whatever she wants you to do, get the orders in writing. Make her do it by the book. If the allegations are concerning like child abuse or something is wrong with your child, take your doctor. If they don't take your child into custody, take your doctor immediately. Take your child immediately to the doctor and have the child examined by a doctor. Ask him to give your child a thorough examination, and then to write a letter stating there are no bruises, marks, or health concerns found on the child. It is very important you do that either the next day, the same day, that night, whenever they show up to your door. As fast as you can get to the doctor. Hopefully it's a doctor you can trust, who knows you, knows what type of parent you are, and knows that you're a good parent. Never, ever go to a doctor recommended by CPS or one of their doctors. All of the doctors recommended by CPS are on the county payroll. They work for the government, and when I say they work for the government, they get paid by CPS. They want to continue to get paid by CPS. CPS brings through 14,000 children a year, so these doctors want to stay on that gravy train. So, always go to your own doctor, or if possible, if you have to get a blood test, a urine test, whatever it is you're going to do, go to your own private doctor. Don't use a CPS physician. If they say, oh, you have to use your doctor, no, you don't. This is an investigation. You don't have to do anything they tell you, and you don't have to cooperate. If the judge orders you to do something, say, fine, I'm going to go get a doctor, and then that independent doctor will send in the results. So another big thing that parents talk to us about as it relates to rights is that the social workers will say, well, you have to get a drug test. No, you don't. If they say that you do drugs, they can't prove you do drugs unless you do a blood test, a urine test, or a hair follicle test. Now, why would you do something of that nature if you don't have to? If she says, well, if you don't do it, we're not going to allow you to see your child, that's illegal. That's against the law. Well, if you don't do it, you'll never get your child back. She can't do that either. That's illegal. She's trying to do whatever she can to gather evidence. Say, listen, you're prosecuting me. I'm defending myself. Here's my lawyer. If your lawyer tells you to get a urine test or a blood test, no, you don't. You don't have to do that. Now, when I say you don't, you don't. If you want to prove to them you don't do drugs, that's fine. That's up to you. But, I sit here and say, well, why would you pay money or go do a test when, nothing is wrong, and it's up to them. The burden of proof with child protection services is on child protection. And 9 out of 10 times, they can't prove their allegations unless, A, you admit it, B, they have pictures or something of that nature, or some video evidence. But if it's just a person calling in an allegation, well, it's up to CPS to prove that allegation. So you don't have to do any drug tests. And if you do a drug test, go to a hospital or an independent lab. Never, ever, once again, go to one of the doctors recommended by CPS. And don't let them say, well, you have to go to this place. No, you don't. You can go to any place you want to get a drug test, and never go to one of their doctors to get a drug test. While we're on that topic of, not the topic of drug tests, the next topic I'd like to talk to you about is the admit, deny. A trial needs to take place in 60 days. Always plead innocent to all charges. Never admit guilt to anything. If you admit to anything, something to you might seem it's like, mundane. You're just like, have you ever shouted at your child? Oh, yes, I've gotten upset and shouted at my child. They will use that against you. In Minnesota, as in most states, which I didn't know and I was shocked to learn, say you've never spanked your child ever, a day in your life, and you told your child, if you get expelled from school, if you get kicked out of school, you will get a spanking. There's going to be a consequence or a downside to that, right? Just saying those words and never having done the act is enough for CPS to pull your child out. They're like, you're being mentally abusive to your child. You're threatening your child. It's terroristic threats. This happened to me. And when I say it happened to me, what I just explained to you is what I said. I told my 10-year-old son that if he ever got expelled from school, I'd give him a spanking. Now, he had never gotten a spanking before. But because I told them that, they tried to put in a charge of terroristic threats. I'm like, are you kidding me? I didn't even do anything. I said, how are you supposed to keep your child in line? What discipline are you supposed to use? Oh, talking in timeout. So, just letting you know, something that you think is simple, just like I did. I'm like, yeah, but he never got a spanking. They're like, so what? So they use anything or everything that you say will be used against you. Don't speak to them. Don't admit to anything. Make sure your attorney is present. But anything that you think may be used against you or anything they're trying to accuse you of anything, stop all conversations. Never admit to anything. And please don't think that CPS agents aren't above of misrepresenting you, misquoting you, telling a lie, fabricating evidence, twisting what you say. That's their whole game. And, it's a word game. It's how they present it to the judge. It could be, you could say something completely innocent, and they'll use that against you in a court of law. So, and they won't give you a break. They won't think you're a nice guy. This is just what they do. And I'll explain to you later. There's another unit when it comes to federal funding in Title IV. And when you read that unit, you'll completely understand why they do what they do and why they take the children immediately. I was not aware of the requirement for Title IV funding. And so when you look at that training unit, you'll be like, aha, now I understand why so many parents get their children taken away from them every year. Mandatory services. It is mandatory for the caseworker to put together a case plan within the first 30 days that a child is removed from the home. It is not mandatory for you to cooperate. Never agree to anything. Never agree to services. Cooperating regarding any services with CPS or case plan whatsoever during the investigation phase, during that first 60 days, is an admission. If you didn't do anything wrong, then you don't have to take services. And if the social worker says to you, well, if you take these services, it'll go a lot smoother for you and you get your kids back a lot faster. No, it won't. What you've actually done is more damage than good. You've actually curtailed that 60-day window because now they're going to go into court and say, well, Your Honor, we want to put the petition on hold. We're working with the parents to try and correct these things. And, we don't necessarily have to have a trial now. Well, see, now they can keep your kid anywhere from 6 months to a year. Or, when I say a year is the maximum amount of time they have to keep your child before they have to file for termination of parental rights. And just by you saying, okay, I'll work with you to get my kids back faster, that is wrong. And I tell every single parent, I said, you have a choice of them having your child for 60 days and being in your life for 60 days or being in your life for 6 months to a year. And I said, I don't know of anyone. I said, if you look at the statistics for child protection services, the average child is in CPS custody for 6 months to a year, every single child that's removed. So their own statistics speak for themselves. There's no working with the parent. That's not what they're doing. They're actually tricking the parent into not making them prove the allegations and not having to go to trial. If they had to go to trial for every single parent, and they pull in about 7,000 children a year, and this is by their own statistics also, they wouldn't have the capacity or bandwidth to do it. So what they end up doing is getting the parent to admit to it, taking these services, getting the federal funding, and then keeping this cycle going. So I don't care what the social worker says. I don't care what the judge says. I will send you the state statutes. You are not compelled to work on any case plan or take any services whatsoever until after your trial in 60 days, no matter what they say to you. If they say you're not being cooperative and it's not going to go good on you, say, fine, it's not going good on me now anyway. But I'm telling you, if you give in and you talk to anybody on the forums, every single person will tell you they didn't have their trial in 60 days when they cooperated and started working on the case plan and started listening to the social worker. They were all tricked, and none of them had that 60-day trial that they were supposed to. So, in closing, this last topic, I'm going to say this. Nothing is mandated until you have your trial, no matter what they say. I'll give you the state statute later on the next unit on the timeline. Only if you're found guilty can the judge then issue a court order for you to do the case plan. Don't let the judge say, well, if you start working on it now. No, don't even listen to the judge. The judge is full of caca also. Excuse my language, but he is. I've seen it time and time again. One of the things I tell people is get the foundation involved, get your family involved, get friends involved. Family preservation is here to help you and answer questions whenever possible. That's why we've put together this training series. Speak with other, FPF parents who have dealt with CPS. Take what everyone says with a grain of salt unless they show you documents or can give you state statutes or can give you, case law. Everyone has had their own dealings with CPS. The problem is that 90% of the people don't truly understand the mechanism, which is why I'm putting together this training series. And so you need to understand the mechanism, the state statutes, and the case law, and all of that will be given to you. View the educational material, take it all very seriously. This is for your own education, and you're fighting for your family and your children. Give CPS names of family members if the children must be removed from the home. They're required by law to consider family members first before putting a child in foster care. Make sure you tell that to the judge. If CPS comes back and says the family is unfit, they say, well, how is the family unfit? My grandmother, my aunt, and then they have to come back and provide evidence for that. So don't just take that, when they say, oh, well, we're not giving it to your grandmother, we're putting it in foster care. There has to be a reason for that because they're supposed to keep it with the family first. Get reference letters from your doctors, your pastor, your friends, anything stating that you're a good parent. It's harder for CPS to legally take your children when they have a crowd of people watching. And the best thing to do is to get that crowd of people watching early on, contact the media, do whatever you can do, write everything down. They don't like scrutiny. If you can afford to get an attorney right away. Don't talk to them at all. If you can get an attorney at the EPC hearing or before and you don't talk to them, they know that they have an uphill battle because the attorney knows, the state laws and the requirements. And if you take this educational training series, and you'll understand what they can and can't do. And a lot of times they will drop the case. I've been involved in a number of cases where we got the attorney involved right away, and CPS ended up not filing a petition. They were like, it's too difficult. They go after the poor and disenfranchised, the people who can't afford attorneys, and the people who they think don't understand the law or don't understand what's going on. And so those are the people that they actually go after first. In closing, I would like to leave you with this one major piece of advice. Do not believe anything that anyone tells you unless you read the Minnesota state statutes or case law yourself, especially anything told to you by the state or county official. That includes the judges. They're all on the same payroll. They all work together. They're all drinking coffee out of the same coffee pot. And if you have any chance of winning, it's with you and your attorney by keeping quiet and working your case diligently and following the state statutes. I'm going to give you state statutes with everything that I present, and you need to look those statutes up. Go Google the statute, read it, understand it. So I'm going to say, in order for them to do this statute they're using, and this is what you have to do, and this is what they have to try and find. So your job is to do the exact reverse or defend yourself. And then you need to go to your attorney and say, this is what I read, here's the statute, here's the case law, this fits my case perfectly. I can't tell you, how much, I ended up doing that, and I've done that subsequently with all my attorneys. I find out what's going on, and in my free time, I'm looking on Google Scholar for case law, and I'll give it to does this help us? Does this apply to our case? Because they're working on multiple cases at the same time. Not that they aren't diligently working on your case also, but it is your family and your children on the line, so you must put in the extra mile. If you're waiting for someone else to come and save the day, some Superman, or you're waiting for someone else to do it for you, well then you're in for a world of disappointment, because that's not how the world works. The only person that takes care of you is you. I'm trying to disseminate information. That's what we do at my core. Hopefully in the future we can get staff attorneys, but until we can get the funding on that, I'm just going to try and educate the members to the best of my ability, and let them make their own legal decisions. A lot of times I feel if parents are well informed, they're better in court than having a public defender, because the public defender is paid by the state and the county, and they're going along to get along. It's not their family. So that's all I wanted to say at this time. Stay tuned for the next video series, or jump right into it right away if you want. Download the PDF that goes along with it, the PDF handout. You need to read and study this and look at the state statutes and all of the PDFs, and educate yourself on how to be an advocate for you and your family. Thank you very much, and good luck.